Welcome back. You're watching The Firm. 3 years, 3 reviews, and the CCI's combination regulations are now set for a 4th revision. This time to fix the Tesco problem, the Thomas Cook problem, invalidate notices, and buy itself some more time. To tell you what all of that means, I have with me Avaantika Kakkar of Khaitan and Nisha Uberoi of Amarchand. Ladies, to both of you, a warm welcome to the show. I'm going to get right down to the first proposed change, and this has to do with what triggers a filing. Now, the triggers that are already listed in the regulations include board approval for the merger, execution of any agreement pertaining to the transaction, any other document, or any communication to the government in the absence of any other document. That has now been replaced to say that in the case of an acquisition being done under the takeover regulations of SEBI, then the public announcement is the trigger. I suppose this is a welcome simplification because there has been confusion earlier on, and I believe the Tesco case was all about this.
That is correct, Menaka. The Tesco case, as you know, involved a filing with the FIPB.
That's right, FIPB.
And that the Commission found had triggered a notification requirement.
Yes.
Because it suggested that this was a binding document that reflected a decision to purchase.
Whereas Tesco, in fact, only notified the CCI later on when they signed
the binding agreement.
Right, yeah.
The Commission found that, of course, that the FIPB application was in fact the trigger, but some of us felt that it was always the binding agreement.
So what they've done really is they've limited Tesco. So now in the case of an acquisition, you will file on the basis of a binding agreement, or if it involves a listed company and a takeover, you will file when the public announcement is made.
Right.
If you go to any other statutory authority, you do not need to go to the CCI. That is not your trigger.
Then let's get to change number 2. This had to do or is regarding the failure to file notice. The current regs say that when parties to a combination fail to file notice, the Commission can initiate an inquiry and direct the parties to file notice in Form 2, that is the long format form. The proposed revision now says that a mandatory Form 2 filing is not required.
It's a very welcome move because it just goes to show that they're not out to penalize industry. As it is, when you don't file a form, you will have to undergo penalty proceedings.
Right.
In addition to that, if you're made to file a Form 2, particularly in a case where you're acquiring a minority stake and you have inadvertently not filed the form, then it's an extremely cumbersome process. So this is a very welcome move.
Well, the third proposed change does away with the ambiguity surrounding the obligation to file a single notice for the transaction that is made up of a series of smaller transactions. So the current regulations say in such a transaction, a single notice may be filed. The CCI now proposes to change that to shall. This, in a sense, confirms their treatment of Thomas Cook.
That's absolutely right.
Yeah.
What they're doing is they're taking away the discretion from parties, and the rule of thumb that they came out with in Thomas Cook is if a series of transactions is done simultaneously, it's approved by the same board resolution, it involves essentially the same parties, they will treat it as a composite. So if a part of those series is not notifiable, parties no longer have the flexibility not to notify it.
Okay.
The problem though with this particular amendment is that if we were to file on the first step and we don't have enough information, it would be an invalid notice. It could be a premature filing, because the amendment regulations also come up with a new amendment which says that in case a notice is not complete or not valid, they can return it. We could have such a situation here. Alternatively, we could have a situation where parties inadvertently consummate one step, treating it as not notifiable, and then you have penalty proceedings. So the rule of thumb now very likely will be a lot more pre-merger consultations with the Commission before a transaction which involves a series of interconnected and interdependent steps.
Okay. My take is a little bit different on this, Menaka. I think it's one thing to say that you can't confuse gun jumping with the need to notify transactions. So I believe that the Thomas Cook case was possibly a gun jumping situation. I'm not necessarily agreeing with what the Commission held, but they use this provision to explain and reason their decision in Thomas Cook. Whereas my understanding always was that this provision was meant as a convenience or perhaps an anti-avoidance. I wonder if it's worth the Commission's time to be spending time determining whether the parties filed on time or whether they filed at all. I think it's more of a form of a substance issue. I'm not sure this was really worth the effort.
The problem might be if we're doing an intra-group reorganization, because we've got an investor coming in, and if I have to go in at the stage of the intra-group reorganization, well then at that stage we won't have enough information for a complete competition assessment. So we go in for the filing, and it only means that the time taken for review is going to be that much longer, because the Commission is also going to want to review all the documentation which I enter into with the investor, because they're going to look at things like non-compete, they're going to look at standstill obligations. So the time for review will actually get longer in practice.
Substance.
Okay.
Not form.
Okay, fine, I get it. So, speaking of the fourth proposed change, and Nisha's already mentioned this, it has to do with notice scrutiny. The CCI has proposed an addition that says it may invalidate a notice if the Commission finds that such a notice is not valid or complete. Now, I couldn't understand that at all. What does it mean that if it's not valid, we will invalidate it? I mean, what are the grounds for invalidation here at all?
So there are no grounds, it's purely discretionary. If they think when you submit a notice that it does not have adequate detail or it's not complete.
But that's taken care of the word complete. So if it's not complete, and complete based on the, sort of the formats that they provided, then I understand that it would be treated as invalid.
Then they will return the notice.
But saying it is not valid, I couldn't understand that the use of those words.
I'm not going to pretend that I understand it either, to be very honest with you. And therefore, the exercise of discretion and how far will we go with that, and whether the Commission really needed to do this. Is this really necessary? When they receive what they believe defective or incomplete notices, they have the power to not even start the clock. The Commission can come back to you and say that there were defects in the notice or that it was incomplete, and please fill it in. And at that time, the clock stops.
If it's not complete, to give you a very, very absurd example, you need an authorized signatory to verify the notice. You have to provide all of that person's contact details. So say I don't provide your email address. If I don't provide your email address, it's a not complete notice. If they can invalidate this notice, and there's no time frame prescribed for this. It means that you as the CCI will return the notice to me. I might not be able to file it within 30 days from my trigger. I will then be exposed to a penalty proceedings, because when I actually do refile the notice, I will not meet the timeline. I will get no time credit for the period when you have actually reviewed the notice to decide this, and I don't get a right of hearing.
By not providing any basis for an invalidation in these amendments or proposed amendments themselves, they're literally leaving you at sea, right? You could be invalidated for pretty much anything, not just incompleteness.
Absolutely. And the point is, I do not believe that the Commission intends in any way to be unreasonable about it.
It's poorly phrased, I imagine.
It's poorly phrased, yes. And anything that gives such wide discretion, I'm not sure it's a great thing. Particularly because of the consequences it will have on a transaction.
Now, while they're not giving you more time, they are buying themselves more time, and that's the fifth proposed change. Essentially, this gives the CCI more time to offer a prima facie opinion on the combination, so 30 working days instead of 30 days. It also gives the CCI 15 extra days if it wants to call for information from any other enterprise while inquiring into the combination, and it gives the CCI another 15 days to seek the opinion of any other regulator or statutory authority. So that's 30 working days plus 15 working days plus 15 working days. So prima facie opinion is now 60 working days, right? That changes your entire deal timeline, doesn't it?
That's right.
I admit, in the beginning when you read it, it seems like the heavens have fallen. But let's hold on for a minute here. We have 30 days to make a filing from the time that we trigger the merger control notification. That no one can take away except the legislature, because that is a creature of the statute. So let's let that be. Now about the Commission. The Commission promised that it would make its prima facie order in 30 days. However, in reality, and I tend to appreciate where the Commission is coming from, that is very little time to make your assessment. They have to keep stopping the clock by asking questions, sometimes perhaps even to buy time. And I'm not sure I can blame the Commission for that. They have to write a reasoned order. They have to approve the combination. They have to say that this doesn't result in appreciable adverse effects, or that it does. And that has to be something they have to think about. So I don't mind the 30 working days.
Well, they can still stop the clock.
Yes, they can still.
What's the comparable anywhere else in the world for a prima facie opinion?
The Singapore Competition Commission takes 45 working days. Menaka, I think there's one actually very big positive for industry out of this. In a complex Form 1 filing, instead of taking a transaction automatically to a phase 2, where you have a further 180-day review the Commission has, they can now choose to exercise this option where they go out and they consult third parties for a 15 working day period, which is defined, and they can go and consult other sectoral regulators. Again, a very big positive. It shows that they want to consult other sectoral regulators for technical issues. So in such an instance, industry will actually benefit because they could clear this in that time period.
However, the other side of that is that they've eaten into their ultimate limit, which is 210 days.
All right, let's see which ones of these become final. Thank you very much, ladies, for joining us. We're a little late in this analysis. The last date for feedback was the end of April, but we still hope the CCI is listening. Thanks very much for watching, and to make sure you visit our website, chat with us on Facebook, stay updated on Twitter. We'll see you next week.
The Firm, India's only show on corporate law, tax and audit matters.